So one of the big focuses in the ongoing Murdaugh murders true crime saga, the story of 53-year-old attorney Alex Murdaugh, his influential family, and the prestigious law firm it founded down in Hampton, South Carolina. One of the big focuses of this story in recent weeks has been the receivers in this case, the folks who have been charged with following Alex Murdaugh's assets. Now, these receivers gave some testimony during a bond hearing last week involving the Murdaugh case. And so we want to take a look at what they had to say because, again, at Fitz News, we've been very closely tracking these assets and matching those assets up with what the receivers told us. So here, let's take a look at what the receivers had to say during that court hearing.
Mr. Lay, let me first of all, for the record, get a little bit of your background in. You're an attorney or partner with a firm here in South Carolina?
Yes.
What's the name of that firm?
Gallivan, White and Boyd.
And how long have you been a member of that firm or partner in that firm?
10 years.
Okay, and you primarily handle civil matters, is that correct?
That's right.
And typically complicated business issues?
Yes.
And you're the former president of the National Defense Lawyers, that would be civil defense lawyers, is that correct?
Yeah, International Association of Defense Counsel. That's
International. Okay. So how about tell the court, please, how you became to be involved as the receiver, and then I'm going to ask you about what a receiver does, again, for the record.
I was asked by several attorneys that are involved in this case to, if I would agree to the role, if I were appointed by the court, and the court that ultimately was a process that was engaged in, there was a motion that was made, and I was appointed as receiver with Mr. McCoy.
And tell the court, please, what your role as receiver is.
My role is, and Mr. McCoy's role is to gain control of all of the assets that Mr. Murdaugh would have available to him. So, and then we assimilate those assets in an attempt to create a settlement fund for any potential folks that have claims against Mr. Murdaugh.
And Mr. McCoy brings to the table not only the civil background, but he's the former U.S. attorney for the state of South Carolina. Is that correct?
Yes, sir.
And I think currently he is now the chairman of the board at Santee Cooper. Is that correct also?
Yes, sir.
So he's got a background in business, civil, and criminal. Is that correct?
That's my understanding, yes.
So, and the two of y'all have worked together on this receivership process?
That's right. We work together.
And let me, you were appointed by what judge?
Judge Hall.
Okay. And do you continue in your role as receivers, both of y'all?
Yes.
And it's the job, as you said just a moment ago, of the receiver to ascertain what assets Mr. Murdaugh has and ensure they're not disposed of, wasted, used in any way, not approved by you and the judge. Is that correct?
That's right. That's right. We assimilate the assets. If there are claims against the assets, we have to manage those, even defend those potentially. And we have to investigate and make sure we have all available information to determine what the assets are.
So let me ask you some basic questions. Have you uncovered any bank accounts that Mr. Murdaugh has?
Yes.
And how many does he have?
He has at least 3 that we know of.
And do you know the total amount of money contained in those assets, in those accounts?
He has, it's roughly $10,000 in.
Okay. So $10,000 in the bank account. And does he have access to that bank account?
He does not any longer.
Okay. So he doesn't have access to that $10,000.
Correct.
And I'm going to talk to you about a retirement account in just a minute. But other than that retirement account, does he have any liquid? By that mean, does he have any cash anywhere that you know of?
By that definition, no. I know the retirement account, and we know the $10,000.
Okay.
I'm at a state bank account.
Now, there are pieces of real estate in which he has an interest, correct?
That's right.
And is he in a position to liquidate those, or would the receiver object? And would the court, in your opinion, substantiate that objection?
I mean, the way that process works, no, he cannot liquidate. We can liquidate, and then, you know, he would not be able to do that without court approval. The court, Mr. McCoy has control, and Judge Hall is in charge of the process.
Can he borrow on any of those assets?
He cannot encumber his assets.
He can't encumber them. He can't sell them. He can't borrow against them. And so, and let's talk about, he does have a retirement account for about $2.1 million. Is that right?
That's right. 2.2 maybe. It depends on what the market's doing right now, but that's roughly what it is.
If he wanted to liquidate that, I mean, if he said to the plan administrator, they wanted to liquidate it, would the money go to him, or would the receiver seize that money?
Well, I mean, he would have to get permission to liquidate from the court because we have control of it. You know, if there is a liquidation at this point, there would be penalties associated with that, which would encumber the settlement corpus that we're trying to protect. So he would have to go through a process to get access to that. We would be notified as receiver before anything is done. At least we should. That's the way the process is supposed to work.
Okay, so I guess in summation, he has no money to pay a bondsman or post for a bond, correct?
I mean, he's got money that he could, there's a process in which he could seek help from Judge Hall to be allowed to use some portion of the settlement corpus to pay for a bond. I mean, we would resist that. I mean, we would resist that. We would resist that as receivers. Ultimately, it's Judge Hall's call.
So it's your position any money he comes into would go into that fund you're establishing to pay victims. Is that right?
That's right.
Okay. And so there's no immediate, even if he were to try to liquidate that, that would take, as I understand it, months to get done, even if you didn't object.
I mean, it would take, I don't know what the exact time frame is to liquidate. I mean, but it would take some period of time before those retirement funds, which are in the market, would be converted to cash. And then they have to, there's tax consequences or penalties associated with it.
And if he did liquidate those, he'd have to pay taxes, a penalty in taxes to get it out, right?
Yeah, depending on how it's invested, he definitely would have to pay penalties, whether it's going in post or pre-tax. But yeah, there would be tax consequences.
So the summary is he's got no money, he's got no assets that he can use to post bond without Judge Hall and you agreeing for him to use, to use his very limited assets to post for bond, correct?
Well, he's got assets. There's just a process in which he has to go through to access those assets.
And are you going to help him access those assets?
Mr. McCoy and I will not be helping him access those assets, no.
Okay. So the Judge Hall would have to give him access over your objections.
I mean, without seeing what he's going to be asking for, I mean, as a basic premise, most probably, yes, he would have to do it over our objections, but, you know, I don't know what's being asked for precisely.
Okay, now there is a sum of money that will come out of a trust to the trustee would be to a trustee, about $360,000. Is that correct?
It is a retirement account of his father who is deceased, and
right, and that would go
into a trust. That's right.
To a trust over which, as I understand it, Mr. Murdaugh does not have control. Correct, but a family member does.
Yes, his son is the trustee.
I'm sorry.
His son is the trustee of the trust.
Right. Thank you, and Your Honor, based on Mr. Lay's answers, I don't intend to call Mr. McCoy It's always good to see him. But I think he would, I don't know that he disagreed with anything Mr. Way said. So there's no reason to put him through that and not waste the court time, but consume more time.